My name is Rex Rank. I'm the Deputy Clerk of the Supreme Court. And if everyone can find a seat, we'll get the introduction started. As a reminder, you'll probably get a few of these. The court will be in session, so please silence your cell phones as we get going. Thank you.
Well, good morning. I'm Martha Williams, and I teach at the Blewett School of Law here at the University of Montana. And on behalf of the university, it's a privilege to welcome you to the Montana Supreme Court's hearing on the City of Missoula versus Mountain Water Company, Carlisle Infrastructure Partners, and the employees of Mountain Water. The court's tradition of holding oral arguments at our universities and now in other parts of the state demonstrates how extraordinarily accessible our government in Montana is. I want to thank the court for inspiring confidence in the judiciary, and by holding this oral argument at the University of Montana here in Missoula, where there's so much interest in this case, and where it hits close to home for many of us in the audience. At least one lawyer in this room remembers sitting just like some of you as a high school student, watching the arguments unfold, and then again as a law student about to graduate, only to fulfill a dream and sit today and get the chance to argue before the Supreme Court. We all hope that the oral arguments today will inspire you to go on and study law, practice law, and perhaps some of you come to the Blewett School of Law and grace us with your intelligence. So for the want-to-be, the soon-to-be, and the non-lawyers in the room, I will first introduce Montana's Constitution, then the three branches of government with a focus on the courts, and then lay the groundwork for the lawyers' arguments this morning by briefly explaining why we are here, how this case got to today's oral argument. So the Constitution. I'll begin with Montana's Constitution because it is an extraordinary document. It was proposed by 100 ordinary Montanans and adopted in 1972 by the skin of its chinny chin chin. Even its preamble is amazing. We, the people of Montana, grateful to God for the quiet beauty of our state, the grandeur of our mountains, the vastness of our rolling plains, and desiring to improve the quality of life, equal opportunity, and to secure the blessings of liberty for this and future generations, do ordain and establish this Constitution. Unlike many other state constitutions, ours makes sure that we get the chance to participate in our government and that we have the right to know what government is doing. So it's in the spirit of accessibility that the Montana Supreme Court takes the time to hold an oral argument here in Missoula, where those affected by its decision get to attend. So Montana's Constitution divides the power of government into three branches: the legislature, our senators and representatives, and the people through initiative write our state laws; the executive, our governor, the attorney general, state agencies, and their officials and local governments implement and enforce the laws. And the judiciary, the trial level, and the appellate court level interpret and apply the laws by deciding cases before them. The courts. Let's focus on the courts because, well, essentially, we are all in court today. There are three major court systems in Montana: tribal courts in each of our 7 tribal nations, federal courts, and state courts. Within those three court systems, there are two levels of courts: trial courts and appellate courts. Trial judges and juries hear and decide disputes in the form of cases. Some go before what we call courts of limited jurisdiction, like the Justice of the Peace, the city courts, the municipal courts, and small claims court. If you've ever paid a traffic ticket, you've probably had contact with the Justice of the Peace or the city or the municipal court. More serious matters go before state district courts. Montana divides these state district courts into 22 judicial districts. The case we will hear today arose out of the 4th Judicial District, which includes Missoula and Mineral County. District Court Judge Karen Townsend decided the case being argued today. In trial courts, parties, with the help of lawyers, present facts or evidence through witnesses or documents. Lawyers make legal arguments for the parties they represent and try to win the dispute. The judge, sometimes aided by juries, determine the facts, decide the case based on the facts and the law. The judge will write out the decision, the reason for the decision, in an order and a judgment. If a party disagrees with the trial court's decision or how it was made, that party may appeal the case to an appellate court. For Montana courts, that's the Montana Supreme Court. In an appeal, the parties are usually bound by the facts and evidence presented at the trial court level. Parties may make written argument, referred to as a brief, and submit their written arguments at the appellate court level. The appellate court reviews the trial court's decision. That's why there are no witnesses testifying to the facts today. The appellate court determines if any errors occurred during the trial court's resolution of the dispute. So the Montana Supreme Court. The Montana Supreme Court handles all appeals from district courts and is comprised of 7 justices: Chief Justice Mike McGrath, Justices Patricia Cotter, James Rice, Beth Baker, Mike Wheat, Lori McKinnon, and James Shea. Next, I'll introduce the case and lay the groundwork for today's arguments. Appearing before the Montana Supreme Court today are Mountain Water Company, Carlisle Infrastructure Partners, and employees of Mountain Water. I will refer to them collectively as Mountain Water. They are appealing the district court's decision. The city of Missoula today is appearing today also defending the district court's decision. So the city of Missoula versus Mountain Water is about the power of eminent domain and the city of Missoula's efforts to condemn Mountain Water, which owns and operates a Missoula water system. So I think it's helpful to explain some of the basics about the power of eminent domain and what condemnation means before I discuss the facts. The law will help the facts make sense in this case. Eminent domain. As with other states, Montana has certain powers of eminent domain. Eminent domain is the right of the state to take private property for public use. Taking means forcing the private property owner to give up the property to the state for a public use. So when the owner of property does not want to sell to the state, in certain circumstances, the state may use its power of eminent domain to force the private property owner to transfer that property to state ownership for the public use. Condemnation is the way the state uses its power of eminent domain to take property for public use. Here's a typical example. Say in Bozeman, when North 19th Street was starting to get so busy, the city and the state said that a new exit and new exit ramp off of I-90 was necessary. The city and the state then exercised their power of eminent domain to condemn a parcel of land where they could then build the new exit and the exit ramp off of I-90. Montana's constitution and the laws enacted by the legislature have lots to say about this. At the very basic level, they require that the condemned property has to be put to a public use, that the state has to pay for it, and that there has to be a fair process. There are 2 phases of condemnation proceedings, a phase that determines whether the state has met its burden to show the necessity for the public use, and in this case, whether it is a more necessary public use, and evaluation phase to determine how much the state has to pay for the property. This case and the arguments this morning are all about the necessity phase. So let's go to the facts in this case, but listen to them with the power of eminent domain and the more necessary public use requirement in mind. What led to getting to the Supreme Court today? Well, there's a lot of history to this case. Let's start with the facts that the city of Missoula has the power of eminent domain and that Mountain Water owns and operates a Missoula water system that collects, treats, and distributes water to citizens in Missoula. Carlisle owns Western Water Holdings, which owns Park Water, which owns Mountain Water. From 1930 to 1979, the Montana Power Company owned Mountain Water. In 1979, Montana Power Company sold Mountain Water to Park Water. In 1984, the city of Missoula tried to buy Mountain Water because it felt it was important to own and operate the water supply system itself. Park Water did not want to sell to the city of Missoula, so in 1984, the city of Missoula took action to force Mountain Water to transfer ownership of that system. Montana law directs that condemnation proceedings go to the district court where the disputed property lies, so in this case in Missoula County. The district court decided in favor of Mountain Water, and the city of Missoula appealed that decision to the Montana Supreme Court. The Montana Supreme Court, as the appellate court, reviewed the district court's decision and held that the district court was correct in part, erred in part, and sent the case back to the district court for reconsideration. I mention this case because you will hear the lawyers and possibly the justices mention it this morning. So shift forward to 2011 when Carlisle bought Park Water and also then bought Mountain Water. In 2014, the city of Missoula again offered to buy Mountain Water, and Mountain Water rejected that offer. Then, in April of 2014, the city of Missoula again sought to force the transfer of the water system and used its power of eminent domain to do so, taking that dispute to district court. So the trial. Before the court, the parties exchanged information about documents and witnesses. The district court then held an 11-day trial on the issue of whether it is more likely than not that the city of Missoula demonstrated it is more necessary for the city of Missoula to own and operate the water system than for Mountain Water to own and operate it. The district court's decision in this case, the district court issued its decision allowing the city of Missoula to take over the water system now owned and operated by Mountain Water. In reaching its decision, the district court explained that it took into account a broad range of considerations: the effects on the employees, profit and out-of-state ownership, public savings, rates and charges, cooperation between Mountain Water and the city, and the effect of having the home office in Missoula, public interest, and the importance of the city obtaining ownership of water rights themselves in order that the city may ensure long-range access to water. In its decision, the district court went on to list the benefits it determined would result from city ownership: stability of ownership, prioritization of the public health, safety and welfare of Missoula residents in the management of the water system, local control of a vital resource, opportunities for public participation in planning decisions, opportunities for cost savings, benefits of coordination, and benefits of coordination. Mountain Water appealed the district court's decision to the Montana Supreme Court. It believes that the district court made the wrong decision and reached it incorrectly. In their briefs, Mountain Water and Carlisle, its owner at the time the proceedings began, and employees of Mountain Water methodically explain why they think the district court made the wrong decision. Mountain Water explains that one of the implications it sees in this case is the finding that a public entity can take a private business simply because it believes public ownership is better, and thus the decision could have a dramatic and detrimental impact on private property rights in Montana. In response, the city of Missoula explains how it believes the district court correctly decided the case and why, saying that it's crucial for a city in the arid West to control its own water. The parties requested oral argument before the Montana Supreme Court as a way to clarify their briefs and have the opportunity to answer any questions that the Supreme Court might have. So the court speaks to the parties in the form of orders. Here, the Montana Supreme Court issued an order setting the time and date and place of this oral argument, and also narrowed the scope of what it wanted to hear from the city and from Mountain Water. In that order, the Supreme Court gave 40 minutes to Mountain Water, Carlisle, and the employees of Mountain Water, and it gave 30 minutes to speak to the city of Missoula. Rex Rink, the deputy clerk of the Montana Supreme Court, will keep track of their time, and mine too. It asked the parties to focus their arguments on whether the district court correctly applied the Montana law that explains the factors the city of Missoula must demonstrate before taking Mountain Water's water system, and to explain how the 1987 case, reviewing the first time that the city of Missoula tried to take Mountain Water, applies. The court will rely on the briefing for the many other issues that the parties raised on appeal. So how did the oral arguments work today? Well, the justices and their law clerks have already read the briefs of the parties. The purpose of the oral argument is for the court to ask questions of the lawyers. They may even interrupt the lawyers as they speak, which most of the lawyers hope they will do. They would like to have a conversation about the law. In making their decision, the justices are concerned with the outcome of this case, but they're also concerned with the outcome of how this case may affect future disputes and future transactions. The justices will not indicate today which party prevails. After the argument, the justices will adjourn and meet in conference to discuss the case, and one justice will be assigned to draft the opinion. The justices will then circulate that opinion and comment on it and perhaps suggest changes to it. You can never predict when the court will issue its decision, but this court has managed to handle a heavy caseload and efficiently, ranging between 2 to 8 months, issue their decision after oral argument. Courts typically handle eminent domain and condemnation proceedings expeditiously, so I wouldn't be surprised if this court issued its decision sometime this summer. The clerk of the court will issue the decision and will print it as part of an official set of court decisions in the Montana reports. In conclusion, this is really cool. We're really lucky to, how many people do you think are in this room today? A lot. I mean, it's a packed house. So it's a tremendous opportunity to be part of our judiciary in action and hear the arguments in this case that has garnered so much interest and attention. There's a feeling that it touches us all. To those in the audience who are high school students, some of you will become lawyers. Of those of you who will become lawyers, a few will become judges. Of those of you who will become judges, perhaps some of you in this room will be on the Montana Supreme Court in the next generation, hearing cases just like this. On behalf of the University of Montana and the Blewett School of Law, I ask you to sit back, relax, and enjoy the flight. No, not at all. I ask you to sit at the edge of your seats, listen intently, and appreciate this extraordinary opportunity we have today to watch this case in action. Lastly, turn off your cell phones. I don't see anyone else explaining this. We will wait for the justices to enter the room, and when they do enter the room, we all stand.
All rise and give your attention. The Honorable Justices of the Montana Supreme Court.
Please be seated.
This court is now in session.
Good morning. On behalf of the court, I would Good morning. On behalf of the court, I would thank you all for coming. Welcome you to cause number 150975, entitled City of Missoula versus Mountain Water. Before we start, I'd like to introduce the members of the court. My name is Mike McGrath. I'm the Chief Justice. On this end here, we have the Senior Associate Justice, Patricia Cotter. Next to her is Beth Baker, Justice Mike Wheat, Justice Lori McKinnon, Justice Jim Shea, and Justice Jim Rice. Parties ready to begin? Counsel? Mr. Luck.
May it please the court. Good morning. My name is Brad Luck with Garlington Lawn and Robinson in Missoula, along with my partner Kathleen DeSoto and Joe Connor of Baker Donaldson. We represent Mountain Water today. William Mercer of Holland and Hart is here representing Carlisle Infrastructure Partners, and Gary Zadek of Ugrin, Alexander, Zadek, and Higgins is representing the employee interveners. I will be doing the argument on behalf of the defendants, Mr. Zadek on behalf of the employee interveners. We plan to share 25 the initial time, and I would.
Anyway, you
Okay.
set it up, it's fine.
Okay, and I'll reserve 10 minutes for rebuttal. This is the third time Mountain Water has been before this court to This is the third time Mountain Water has been before this court to defend its right to provide the highest quality water services to the city of Missoula.
Sorry, I'm not sure the mic is working. Can people in the back hear?
No, not very well.
It's like soccer.
No time. Test?
Yes. There.
Test.
Yes.
Let me start again. This is the third time Mountain Water has been before this court to defend its rights to provide the highest quality water services to the city of Missoula. We appreciate the opportunity, consistent with the direction of the court in relation to oral argument, to discuss three of the reasons why the preliminary order of condemnation should be reversed, remanded, with directions that the city's condemnation case be dismissed. First, the district court committed error in approving the city's strategy to limit financial evidence, thereby making it impossible for the city to meet the more necessary standard. Second, the district court erred in adopting a general preference for municipal over private ownership, thereby inappropriately creating a judicial preference that's unsupportable in the law of the state of Montana. And finally, the district court erred in finding that the city had met the high burden of more necessary on the record as a whole. We believe that a review of this record will document the propriety of reversal on any or all of these interrelated considerations. We must note at the outset that two things permeate our discussions. Both are Montana treasures. They are the inalienable rights and protections of the Montana Constitution and the wisdom and perspective of Justice Sheehy discussing the more necessary clause, more necessary standard in the prior Mountain Water Company cases. Every discussion of eminent domain in this state must begin with Article 2, Section 3 of the Constitution. All persons are granted inalienable rights, among them the right to acquire, possess, and protect personal property. It is stunning that the City of Missoula, in its findings, proposed findings and conclusions, and the district court in its proposed order, didn't even cite to this bedrock right. It's just as revealing that the City of Missoula and the district court did not cite to the many decisions of this court, making it clear that eminent domain statutes will be strictly construed favoring fundamental rights, and that rigorous review of the statutes and the procedures must be applied in every condemnation case.
Council, reference is made in Article 2, Section 29. Pardon?
You have to push.
Reference is made in the Declaration of Rights as well to eminent domain. So we have both eminent domain reference and ownership of property contained in the Declaration of Rights. Does that equalize them somewhat in terms of our analysis?
I don't think so at all, Your Honor. As far back as 1895 in the Anaconda and Pacific, or Butte and Anaconda Railroad case, this court discussed how important it was that we have strict review of the facts, strict findings, and that we're looking at the public welfare. There may be a balancing, but under these circumstances, especially the statutory basis providing it being more necessary, and especially with the guidance of the past litigation in this case, believe that we are more concerned about fundamental rights, and we'll see where the city's rights, if they can meet the standards and the more necessary standard that was adopted by the legislature.
Well, since you bring up that case, in that case, we said that although the court has to be mindful of the constitutional guarantee of the individual right of possessing and protecting property, we have to be equally impressed with the declaration that the good of the whole is the very foundation of the Constitution. So I guess in considering how the Constitution informs the more necessary test, to follow up on Justice Cotter's question, does the Constitution favor one right over the other?
I don't think it can, Your Honor. I think what it does, what we need to do is apply it in the context of this case with the legislative direction and this court's wisdom and input over the years and how we might balance those considerations. And that's exactly in the whole what we want to talk about today. Justice Sheehy's frank observations in the first case are worth noting. He warned that the city's condemnation right created a frightening power. He indicated that all parties are equal before the condemnation statutes, and the city of Missoula stands in no better stead than Mountain Water to operate the local water system. Finally, he indicated and expressed a concern for unsupported financial assumptions that give rise to mythical savings, allowing a government to attempt to take private business. This wisdom is appropriately heeded and considered on this record. We believe that the required rigorous review of the record will indicate that the City of Missoula, taking its third bite at the apple, failed as a matter of fact and law to meet the rigorous requirements of the Constitution, the considerations of the prior Mountain Water litigation, and the wisdom of Justice Sheehy. We believe the record will review that the City of Missoula wants but does not need the Mountain Water Company. We've prepared a handout because we believe it will assist the court throughout our discussions. Page 2 is a listing of the findings and discussions in the previous litigation regarding the parameters and definition of the more necessary clause as it applies to this exact kind of scenario. We believe it's totally applicable today, and we'll be discussing that throughout our argument. Several of the next pages there relate to a further later section of our argument where we talk about the overall proof in this case, but we would note that pages 3 and 4 document the complexity and the growth of the Mountain Water system over the 30 years since the first condemnation action. Page 5 documents some of the statements of the city in relation to Mountain Water's operation before this condemnation case was filed. Most notably, the mayor representing the city himself indicated that it was not necessary in 2011 to take the assets of Mountain Water. And in 2013, the mayor on behalf of the city indicated that Mountain Water and Carlisle were good stewards of the water resource. The Clark Fork Coalition agreed. Page 6 of the outline sets forth some praises in this record of the Mountain Water operation, including an exceptional commendation from the Department of Environmental Quality after its analysis of the system in 2013, commending the company for operating a complex system at the highest levels, indicating that its management and operation was at the highest levels. Moving to issue number 1. The city's litigation strategy regarding the financial information in this record requires reversal because of a failure of proof. Page 7 of our handout graphically illustrates the fundamental and pervasive error committed in relation to the financial issue by the district court.
Before you get to that, when you talk about the factual errors, in your brief, it may have been Carlisle's brief, there's a discussion of standard of review, and there's actually an allegation that the city has applied the wrong standard of review, and I was having some trouble understanding that. Is it a completely factual determination we're considering here in terms of the more necessary portion of the statute, or is there a different standard of review that you're advocating we apply, which compares?
Your Honor, we believe that it is a de novo review for correctness on this basis. The court has indicated that questions of law, including statutory interpretation, applied to particular circumstances, require a de novo review. The court has also indicated that mixed questions of fact and law require a de novo review. One of the difficulties in this case is that if you study the findings of fact, you'll see that several of them are conclusions of law. They all go to the fundamental determination, was it more necessary? On that basis, looking at it as a whole, we would argue that it's a de novo review. But as we discuss the evidence, if we look at substantial evidence, it's also clear that the district court misapprehended the effect of the evidence, and if you stand back and objectively look at this record, clearly made a mistake.
So does the standard of review require a comparison between, for instance, the valuation method? In other words, does the standard of review require a comparison of one alternative versus another alternative in assessing under the statute whether this is the best for the ratepayers?
And that's exactly, I think, what I want to talk about in relation to this financial error in the record, Your Honor. But I think the direct answer is it's not the valuation proceeding. But if we're going to check unsupportable financial assumptions, there has to be some range of value to be considered to see if the calculations make any sense.
All right.
The city chose to base its taking case on the fact that it was more necessary financially for it to own the system based on several financial promises. It promised it could afford the system. It promised it would have lower rates for 5 years, that it could operate it more cheaply than Mountain Water does, and that it would pour every year significant capital expenses into the system. As a result, the district court properly indicated that matters of value, asset value, debt ceiling, rate structure, and bonding capacity would be central to the taking hearing. On page 8, we have several of the city witnesses, virtually all of the money witnesses, indicated that they couldn't determine if it was affordable and the other financial ramifications of the city taking this system without knowing what the acquisition and bonding costs were. And what follows from that is, unless you know what the bonding costs are, which are dependent on the acquisition costs, none of the calculations make any sense. But then, on the 8th day of trial, the district court abruptly reversed itself at the request of the city and limited evidence in relation to value, bonding, and then everything that went along with it.
Counsel, as a practical matter, now that the commissioners have set a value, why would we remand to have your value evidence admitted in another necessity trial?
Your Honor, our position is that the evaluation, the approach, the entire presentation of the case, which appeared to be a litigation strategy rather than a management plan, relied on the $77 million figure we are working on, and they based their whole case on that. They chose to do that. As a result, the proof failed. More necessary was not met, and it should be reversed, not for a true new trial, but for dismissal. The city had its chance. The city offered its employees over objection to repeat out of context what others had calculated in relation to bonding. It chose not to offer the witnesses it listed that could have provided direct testimony in relation to bonding, capacities, could they afford the system, and what were the other ramifications. Clearly, the effort was to block an airing of these considerations. If the city was so sure about its financial situation, why did it move to block the presentation of financial information? The court then compounded the problem. It allowed the city's witnesses to give all of their calculations and financial opinions over objection on the basis of a $77 million total bonding. It is clear now, it was clear then, but it's very clear now, that that is woefully insufficient. We know now that the actual taking value is $88.6 million, some $38.6 million higher than the city's offer. To that must be added interest, costs, and expenses on both sides as determined by the court, $3 million in contingency fees that the city of Missoula negotiated with consultants and out-of-state bankers, and then the transaction costs.
Mr. Luck, because the $88.6 million is within the range discussed by Mr. Perdue, does that ameliorate in any way the effect of the exclusion of the other valuation evidence?
No, Your Honor. The Perdue testimony was very limited, and he answered hypothetical questions about rates at different values, but wasn't allowed to go into the vast area of other affordability issues, and no evidence was allowed in relation to valuation. So at least the court could have determined a credible range, as it did in the initial Mountain Water case, to determine whether there was any support for these financial assumptions. The only thing we know hypothetically from Mr. Perdue is this promise about 5 years of holding rates is going to go through the window. Numbers. We don't know what the number will eventually be. It's certainly north of $100 million for total bonding. Could be as high as 125. We're going to talk in a few minutes about Mr. Close, who the city relies on for opinions about how many millions of dollars are needed in this system, which we believe is totally overstated. But his testimony was, if you add his repairs into the $77 million already calculated by the city, it could reach $143 to $175 million. The court itself recognized the error when it stated, maybe I shouldn't have let him put that in. Maybe I should have made them redact it, but I didn't, and so it's there, and that's what we have to deal with. Well, what we have to deal with is all the assumptions, all the testimony, all the assurances made on that $77 million bond are all wrong. What we have to deal with is that this record has no competent evidence upon which any of the critical financial findings could have been made. We have no idea on this record what the city can afford, what the rates will be, whether they can put any money into capitalization, and this nonprofit argument goes right out the window also. The minimal profit allowed by the Public Service Commission for Mountain Water is going to be dwarfed by the interest and principal the city pays on this inevitable bond if it gets this taking to out-of-state bankers and out-of-state investors. The city's litigation plan originally was to promise the stars financially. It then changed to choke off all the evidence to give an honest airing to its position. Then it chose to present unsupported financial assumptions. In the prior case, that was called mythical. The product of the city's choice, Your Honor, goes to your question, is creating clear air, failing to meet the more necessary standard. The only response to that can be reversal with remand to dismiss for failing to meet that standard. These problems, these financial problems, are further compounded by the city's alleged business plan, Exhibit 1499. It's preliminary by title, didn't appear until 12 days before the hearing, was based on the $77 million figure. City witnesses indicated they didn't even check with their bonding people about any of the financing in that. They list in that business plan all their experts, but they didn't consult with them in putting it together. The city admits in that plan itself that it was subject to the true acquisition costs, and then it states it cannot accurately predict what capital expenditures it will be able to make. Scaringly to me, it also mentions a continuous issuance of further bonds as necessary to meet financial obligations. The district court, in one line, finding of fact 69, indicated the city has a credible plan for managing the system. Nothing could be further from the truth. There's no basis whatsoever for this finding based on that plan, and this implicates our next discussion in relation to general judicial preference. It also supports the idea that it's a litigation plan, not a business plan. As an aside, one of the things that's mentioned all the time about municipal ownership being better than private is long-term planning. This management plan doesn't even work next week. If you want to see long-term planning, take a look at the filings and reports of the Mountain Water Company to the Public Service Commission, analyzing issues, analyzing cost basis, cost-benefit analysis. That's what planning does. That's what a sound business like Mountain Water does. It's imperative to keep in mind, if Mountain Water makes a financial mistake, the Public Service Commission is there to protect the consumers. If the city makes a financial mistake, nobody is there to protect the consumers. The bond covenants will require that they raise rates to take care of any financial obligations in the mismanagement or the error in acquisition of this system. And that's why it's important that the city should have been required to be put to its proof. When it chose not to, it set the stage for failing to meet the more necessary standard, and that requires reversal and dismissal. We can't have a fourth bite at the apple. We can't have a fourth trial. They knew what the roadmap was. They touched the bases in the litigation strategy, touched all the subjects. But when you look at Exhibit 2, you'll see that virtually every one of those considerations describing how the city failed to meet the more necessary standard in the 1980s apply absolutely on this record. Second issue.
Counsel, before you get to that, does any part of the necessity phase inform the valuation phase? In other words, how do you, if you've got a valuation that's at 77 million and one versus 150 million, and you've got a different determination as to whether it's necessary, more necessary, how does that determination in the necessity phase inform, if any, and how does a district judge get around or deal with that situation?
Your Honor, I think you hit exactly on the heart of the consideration. The district court indicated that, well, the valuation stage is next, we can't bring in this evidence. But we know, based on prior case law, especially on this case, we must have something to test the financial assumptions. Otherwise, there's no way in the world to determine whether it's affordable or what the other financial ramifications from rates to capitalization might be. The district court judges are required all the time to make these evaluations. What's more probable? What's more reasonable? What should have happened here is evidence should have been allowed so the court could have determined, by way of credibility, analyzing the evidence and the witnesses, what an appropriate range would have been, and test the calculations on that basis. That's exactly what happened in the prior litigation. I'm running out of time. I'm going to hurry. We knew this was going to happen. It's critical to talk about a couple more things. One is the judicial preference. The city paraded before the court several witnesses, all of whom gave the philosophical opinion that it was better to own municipally than privately. We've got a list of those people on page 9. Half of them said Mountain Water was doing a great job. The other half knew nothing at all about Mountain Water's operation. Their position and the case of the city of Missoula in relation to the preference is totally philosophical and is totally political. There's a good example if you look at the testimony of Mr. Korsmith. He said the system was great. There was no reason that he could see in the record to do anything about it for the city to take, yet the court issued findings, broad findings, discussing the propriety of municipal ownership over property ownership based on testimony that indicated there was no reason whatsoever to take the Missoula water system. It was totally a preferential, totally a theoretical situation. There is no basis in the Constitution or the laws of the state of Montana to create a preference for municipalization. If we add that to the frightening power of condemnation referenced by Judge Sheehy, we're going to have a disaster, a potential disaster. Certainly we know that it's not authorized under the law or under the Constitution. An aggressive municipality can take that judicial preference and run with it, which would be wholly inappropriate. But as it applies here, if you study the findings and conclusions against the evidence, you'll see that the district court adopted the city's approach of needing a preference, and that the findings and conclusions are ripe with that error throughout the system, and on that basis, the matter should also be reversed, remanded, and dismissed. I want to talk a little bit quickly about some of the facts that are important. If you look at the handout, you'll see the money that's been poured into the system. In its appellate briefing, the city boldly states, Carlisle's not put a single dollar back in this system. That is totally disingenuous, and it's really indicative of the city's litigation strategy in this case to overstate without foundation. The record verifies, and the city knows full well, all net earnings of Mountain Water during the Carlisle ownership were rolled back and invested in the system. Not $1 of net earnings went out of the system. In fact, Mountain Water invested in its system the maximum amount of dollars that the Public Service Commission allowed it to do. The city also overstates the leakage situation. There's leakage in the system. It's 100 years old. It's been going on, and Mountain Water has been working on it for several years in a cost-benefit analysis approach, and it has had great success. 19% reduction in leakage since 2007. Its plans are based on rigorous cost-benefit analysis, something that government apparently is not too keen on doing, as we see from the planning and approach of the city. But in the end, it's big publicly, it's a big statement about leakage, but the fact of the matter is all the water returns to the aquifer. National experts have indicated that under the circumstances it's appropriate, and finally the city has no plan to deal with it. It has done no cost-benefit analysis, and it has done no system analysis to determine the situation with the piping. Final point. A lot is going to be talking about the money that needs to be pushed into this system to make it better. The fact of the matter is that's based on one witness in terms of underground piping and capitalization, Mr. Close. On the stand, it was verified he did no cost-benefit analysis. He didn't know the condition of the pipes. he gave a theoretical opinion, and when faced with the actual investigation, the actual digging up of pipes and assessing them, all of his estimations on the condition of the pipes were proven wrong. In fact, the pipe he said needed to be replaced in the next 10 years had only depreciated 25%. Ending this part, I'd only say we see as a litigation strategy. Yes?
Saying you're going to give him a chance.
Yeah. Yes, I am, Your Honor. We would respectfully submit the record requires reversal.
May it please the court, counsel, I'm a bit like the second speaker after Edward Everett at Gettysburg, who had 2 minutes. I have 4. I'm Gary Zadek. I'm here representing the 39 Missoula-based women and men who've operated this system. They're here before you today. The city agrees they provide exemplary service. The city admits they provide reliable and safe water. And yet the city's plan is to harm them. When government takes a private business by force, the law should not allow the employees to be harmed. The city has to pay present fair value for the chattels, but it wants to cram down the employees' wages and benefits 32%. That's not what government of the people does to these people. It should not be allowed. It's bad policy, and I believe the 1987 and 1989 decisions do not allow harm to the employees when the government takes a private business.
Mr. Zadek, would you please outline what the harms are going to be for the employees?
I will, Your Honor. Number one, the mayor admitted that he cannot match their pay matrices. They have cost of living escalator, which he would agree to for 5 years. He would not agree to market-based surveys that adjust their pay annually based on water systems, public and private, of the same size. It's a market-based survey done by an independent company. They also receive merit raises. He could not commit to that. He could not commit to matching their benefits. He would not commit to giving them years of service credit for retirement. They'll lose 5 years of vesting under city ownership when they're shifted to PERS.
Mr.
Those
Zadek,
harms were set out in the exhibit by Michelle Haley. Yes, Judge.
What about in terms of the broader comparison that Liberty's guarantee was only 18 months?
The Liberty president testified at trial and also presented a letter that at least 5 years, but his testimony at trial was, we want these people to work for us forever, and in fact, Mountain Water has a history of people working there, advancing within, and remaining there to retirement age, and he made that commitment.
But what's more binding? I mean, the testimony at trial or the merger agreement, which set forth the 18 months?
We believe his testimony at trial and his assurances in writing to the employees, and that letter is in the record, that he would retain them all. There would be no reduction in wages or benefits. Now, the city, I asked the mayor, paragraphs 91 to 95 of the amended complaint, signed under Rule 11, which for the audience means under oath, you're verifying it, that it's true. The city stated in its amended complaint to alleviate any concern that might be felt by any Missoula-based employees about losing their jobs. The city intends to extend employment offers to all existing Mountain Water Company employees who reside in Montana. Such offers to match their current wages and benefits unless city wages and benefits are superior, and they can have their choice. I asked the mayor, is that true? His answer was, no, sir, that's no longer true today. Things have changed. The mayor then said, we want to negotiate. And I asked him, what's to negotiate? Isn't the easy answer simply to say to all employees, we will hire you all, we will match your wages and benefits, you won't suffer harm? And his answer was, Gary, that's the easy answer, and that's not our answer. And so the evidence of harm was undisputed. And in 204 paragraphs of findings of fact covering 64 pages, the district court devoted one sentence to the harm of the employees, simply stating, the plan of the city is reasonable. That's not the standard. That's not even a finding of fact, it's a conclusion of law, but the standard is harm. And so, when government seeks to take a private business, these hardworking women and men deserve protection just like the chattels, to be matched for their present pay, benefits, terms of employment going forward. They shouldn't suffer harm. The district court refused to allow us to put on evidence of harm, stating in an order refusing to stay the valuation. We can hear it later. When is later? This is later. And so these hardworking men and women deserve the protection from harm from their own government. Justice should take the high road here and protect these folks. Thank you.
Schneider?
Good morning. May it please the court, Harry Schneider and Tasha Jones on behalf of the City of Missoula. In an effort to obtain a reversal of the District Court's June 15, 2015 order, defendants argue that there was no substantial evidence to support those findings of fact. Appellants would have you believe, and I quote from the Mountain Water Company brief, Judge Townsend applied philosophy over proven fact. She decided by generalities about municipal ownership rather than by facts particular to these circumstances. And in the words of Carlisle, the district court endorsed a scheme under which public ownership always will prevail, crafted tests that always disfavor private ownership. That is not, in effect, saying that she was predisposed and didn't pay attention to the evidence, only a philosophical bent. That's not what should happen in any Montana courtroom, and it's not what happened in this one.
Well, let me ask you about that, counsel. The findings that I think the other side is referring to are those entered by the district court, and I'll just read you a couple to start with. One says, private companies are not well suited to the promotion of public interest goals because it requires them to step away from pursuing profits and return to stockholders. Private ownership is unlikely to provide either stable ownership or locally oriented management. And I've just read a couple. Actually, there are many of these types of findings in the district court's order that were entered as adverse findings to Mountain Water, but are really inherently characteristic with any private company. And the application of principles as these statements are would predispose condemnation necessary in any case. So how can we deal with those very, very broad statements? That's obviously not the law. And can we excise them? Are they harmless error, or are they so riddled all the way through the opinion that it creates reversible error?
My answer is you should look at them, of course. You should consider them, and you should evaluate the evidentiary record on which those observations were made. I would submit that for every one, such as the one you've read, there's more than one which is based on the facts peculiar to this particular case, this particular owner and operator, and this particular city. Sure, those observations were made, but in context, when you read the findings, all 67 pages, you'll see, I believe, that they're based on the evidence that was before Judge Townsend. And it was based on hard evidence, meaning witnesses, factual witnesses with personal knowledge, also meaning experts who came into court with sufficient knowledge, experience, and training to offer an opinion. And there were such experts, and that's evidence. And she relied on that in making the particular findings. And yes, those observations are made, but they are not exclusive to the others which are fact-specific. And I would say that the observations are based on those facts and the evidence and the careful sifting and weighing of the evidence that was presented in court every day for 11 days.
Counsel, to follow up with Justice Rice's question, there were no complaints made of Mountain Water by the city, and also the PSC had no, I mean, they had approved or were on board as well with the manner in which it was being managed. So how do we find more necessary, or how does a district court find that in our review, when there has been no effort to set out what those problems were with the water company and to correct those problems?
I believe the answer is this. There's nothing in the statute, there's nothing in the case law, certainly not in the 1987 Missoula versus Mountain Water Company case, that would read into the statute or the law a requirement that a city, in effect, put out a notice to cure, such as you might find in an arbitration agreement, and engage in a give and take where you give notice of a complaint and the recipient has an opportunity to try to cure it. So it's an interesting approach to suggest that the law requires that the city give notice prior to commencing a condemnation. There's no such requirement anywhere. What is required has been satisfied in this case, and that is an offer to purchase that's declined and a trial on substantial evidence to prove that it's more necessary, meaning that the proposed use has identifiable benefits, conveniences, and advantages that are not going to be present if the status quo is maintained.
But we have the mayor making a statement.
As he does,
Nothing changes from that statement in terms of the manner in which the water company is running the business.
if I understand you correctly, that there will be a smooth transition to the city's own operation of the water supply system. Yes, that is the goal, as I understand it. But there are absolutely going to be benefits that will be conferred upon municipalization of the water system. And those were the subject of substantial evidence in this trial.
Mr. Schneider, a question about the public good here. Does the public have the same recourse against a municipality, against the city of Missoula, if there were a serious financial mistake or a breach that resulted in degraded water quality? Does the public have the same recourse against the city that it would have against a private company and through the PSC oversight?
I believe that it has an equivalent, if not better, recourse. I wouldn't say it's exactly the same because the nature of the operating entity will be different. But as the court found, the governmental oversight in 128 cities, towns, and municipalities in this state today, all but one, works well. And there was substantial evidence to support that. Alec Hansen, 32 years at the League of Montana Cities and Towns, testified based on his extensive knowledge of how that system works throughout the state. John Runquist from the city of Helena, David Nielsen from the cities of Deer Lodge, Glasgow, and others testified it works well.
But the fact that it's more common among the cities in Montana doesn't mean that it's more necessary, does it?
No, not necessarily.
And so the question is, what is the public recourse if something goes awry?
Public recourse is, among other things, the electorate makes a decision on whether or not current city leaders are retained. As far as some monetary claim, if that's what you have in mind, I don't know that there would be an opportunity to sue the city for some reason. But if something goes awry with the water system, whether it's privately owned or municipally owned, it's going to be fixed. It has to be fixed because it is the sole source, other than wells, for the citizens of Montana. And the cost of that repair will be borne by the ratepayers one way or the other. Under private ownership, the opportunity is to replace equipment and defects and aging equipment by paying cost plus 9.8%. If it's owned by the city, the opportunity is to replace at cost. When the defendant's expert, Art Laffer, President Reagan's economic advisor, was asked the simple question, as a matter of rational economic behavior, if you have the opportunity to replace equipment and infrastructure at cost or at cost plus 9.8%, what's the answer? He said the rational economic decision is to replace at cost. And that is how any problems will be fixed. In that example, less expensively than under private ownership.
At the $88.6 million valuation, will the city have to pay bondholders more than that 9.8% rate of return?
The evidence is no.
And what evidence is that?
That's the modeling that was done by the Springstead and the Nick Dragisich, and also the fellow from, Springstead did the modeling on what the bonding capacity is of the city based on certain assumptions. And by the way, those assumptions were tested in this trial. When Frank Perdue was on the stand, he was allowed to testify as to a $75 million valuation, I believe it was a $100 million valuation, 125, 4 different scenarios. Judge Townsend permitted the evidence of the bonding capacity and what would happen if the price was higher or lower in that trial. There was ample opportunity.
And just quickly, now that you mention that, I was advised by the clerk of our court that we don't have the trial exhibits in our record, and that you guys are working that out, and I just want to make sure that that's going to happen. Okay,
That's my understanding as well, and it was news to me as well.
okay.
Yes, that will happen. But it's also in the testimony. If you were to take a look at the valuation testimony when Mr. Perdue was on the stand, you can take a look at his testimony. First of all, take a look at findings of fact 119 and 120, where the court identifies the evidence that was allowed and what the conclusions were from that evidence. Frank Perdue's testimony is at page 2230 of the transcript. And if you look at pages 2232 through 57, you will see some colloquy with the court and counsel about various hypotheticals that he could testify to show exactly what defendants would now have you believe was an error. What happens if the price is higher? The answer is it costs more. And maybe at the higher prices, we're not going to be able to hold rates for 5 years as the initial modeling accomplished. But it didn't change the outcome as far as there are substantial savings. Substantial savings in no property taxes. Substantial savings in no administrative costs paid to executives outside of the state. Just to give an example of one among many, as we know from the 1980s case, the so-called home office costs are a relevant consideration, or in Justice Sheehy's words, a relevant circumstance that should be considered. So let's take a look at that. Findings of fact 88 through 91. And by the way, Mr. Lynn testified by deposition. He's the #2 guy at Carlisle. There was no new money put in by Carlisle. Certainly some of the mountain water revenues were put back in infrastructure, and we've not suggested otherwise, but Carlisle put in no new money. That's clear. Let's take a look at the home office expense. And let's do it this way. Let's see what the evidence was. Let's not talk about platitudes or some academic discourse about philosophically which do you like better, private or public. The evidence was this: $2.1 to $2.5 million per year goes to California from the rates paid by Missoula ratepayers. 30% of the holding company in Downey, California, overhead costs, all their costs are paid by Missoula. Salaries of their officers. The Missoula ratepayers at the top end pay a third of the $540,000 salary for an executive in California. Director's fees, travel and expenses. It goes on and on. And if you want to take a look at the actual line-by-line items, it will be, when the exhibit is before you, 1246, page 35. Importantly, it's mandatory. They've got to take those, quote, services, or rather pay for them, whether they use them or not. Can they seek local services at a lower figure? No, it's mandatory. The evidence was that the city has expertise and that there is local talent that could provide those services. It's done in 128 other water systems. But that's what we learned, and that's what the evidence was. So let's take a look at what the evidence was by the defendants. What did they offer with regard to whether those were necessary expenses that should be borne by the ratepayers of Missoula? Here's the answer. Well, the PSCs approved it, so it must be good. It must be just fine. Did they bring in a witness to say, we can't find within the state of Montana or the city of Missoula the kind of services to be provided that we get from California? They called no witness. They put on no evidence to show that the alternatives were not available. Mr. Schilling testified, yeah, they pay a third of my salary. How often are you involved? Not very often. Mr. McGinnis, the chief engineer, was asked the following question: how much of that services are you going to use in the coming year? Answer was, well, I don't know if I'll use any. But you're going to pay for it no matter what, use them or not, right? Answer, correct. So if you take a look at finding of fact 76, you'll see that that is the recitation of the very evidence that witnesses provided through sworn testimony based on personal knowledge, and it is reflecting the exhibits which were introduced into evidence. To stand here today and say, well, they just decided that as a philosophical matter, the district court decided, oh, public is better than private, betrays everything that happened with regard to that home office expense.
Counsel, speaking of the findings of fact, Mr. Luck is encouraging us to review the decision of the district court de novo. And it's my understanding from the Mountain Water case and Montana Power Company versus Burlington Northern that we are to review findings of fact for clear error. What is your position on that?
The standard of review with regard to legal conclusions is correctness. I agree with that. The standard of review for factual findings, the evidence that was considered, is whether or not there was substantial evidence to support them, whether there was clear error. Even if there's evidence which support a different outcome on a finding of fact, the appellate court, as you know better than I do, is obliged to give deference to the trial court's decisions with respect to a determination of fact. She was the fact finder. And you are not to substitute your judgment in a de novo review with respect to any of the fact finding. That's my position on the standard of review. With regard to the point that I was making about whether or not this was an academic exercise, let's just look at another, and we could go on and on, I won't, but let me mention one more. Public opinion. We know from the decision in 1987 that public opinion is a circumstance or consideration that the district court should take into account. In fact, it was sent back with those instructions. Was this a philosophical conclusion by Judge Townsend, or was it based on any evidence? Let's take a look. Mayor Ingen testified at page 124 of the transcript that he ran for office on a platform of trying to seek ownership of the water company and got the public support which resulted in his election. Councilman Van Lossberg and Weiner said the same thing. They talked about community meetings where people spoke up and endorsed the idea. In one of their words, it wasn't even a close call. Citizens testified. Professor Birchfield from the University of Montana, Dina Mansour, Miles McCarville. And finally, the city put on evidence of a public opinion poll, scientifically undertaken by Harstead and Company, a respected outfit, and they found that overwhelmingly the public supported acquisition of the water system by the city, and at some 80% figure, trusted the city to look out for their interests with respect to the water. That's evidence. It was cross-examined. The credibility of the people talking from the stand under oath was assessed by the district court. And let's see what the contrasting evidence was. There was none. There was no opinion poll, no survey that defendants chose to offer or introduce at trial. And so when you stand here today and say, well, this was just a philosophical preference by the district court, my answer is no. Take a look at the record. Take a look at the transcript. Those findings of fact on public opinion, which are at findings 46 through 53, are based on the testimony. They're based on the evidence, which was fully considered, carefully weighed, and which informs absolutely the findings of fact that were entered. The same thing can be said with respect to the condition and quality of the plant. Was there any evidence to support her findings at numbers 54 through 63? Take a look at just 57, page 17 of the findings, where Judge Townsend reviews what she heard from the witness stand with respect to the quality and condition of the water system, at no fault of the current employees. In the testimony of basically any of the witnesses called by the city who were asked, have the employees done a good job? The answer was they've done a very good job with the money that they were given in capital expenses, within the constraints that were imposed by an out-of-state board of directors, which approved every CapEx expense that could be spent. What did Judge Townsend find? The mains were 50%. 50% of the mains were 45 years or older. 20% had already exceeded their useful life. The wells were in fair to poor condition. They were antiquated. They were corroded. The HVAC systems were out of sync. Chemical feed systems were compromised. The pumps were operating below industry standards with regard to efficiency. The pumps needed about $4 to $7 million to bring them up just to industry standards. 19% of the customers are unmetered. And the testimony from other witnesses from other cities, Helena and so forth, testified, if you meter your system, you're going to have a lot better bit of information on leakage and how to fix it. With respect to the dams, the judge found that there was leakage, seepage, erosion. And the U.S. Forest Service had sent a letter saying it was grossly negligent to maintain one of the dams in the condition it was. And the leakage. Every witness, city or defendants, said that they know of no other city, town, or village in this country that has leakage of 50% or more. Missoula stands alone. Today, more water goes to leakage than arrives at the faucet of the customers. It's really quite unprecedented. And leakage, the witnesses testified, is an indication of quality and condition. So to answer the question, was there evidence to support that finding? There's abundant evidence. Was it conflicting? In this instance, yes. This is one where the defendants chose to contest the evidence. What's a trial judge to do? A trial judge is to weigh that evidence. A trial judge is to assess the credibility of the witnesses. A trial judge is to make a determination of which evidence is more credible. And this judge made a finding, based on the evidence, that the more credible evidence was that the system was in poor condition and that substantial sums are necessary. Yes, Justice McKinnon.
Counsel, there were some earlier questions in Mr. Luck's argument concerning the constitutional issues of eminent domain and private property rights. And I believe that we have answered some of those questions in our Montana Talc decision, which construes statutes narrowly and restrictively and recognizes that eminent domain may only be exercised by the state pursuant to a legislative grant. So here, the city has exercised that right pursuant to 70-30-111, and specifically one of the uses enumerated in 102, subsection 6, water and water supply systems as provided in Title 7, Chapter 13, Part 44. So my question to you is, how has the city in the first instance satisfied the requirement that it cannot exercise eminent domain unless there has been a specific legislative grant allowing that exercise and consistent with our authority that that is to be construed very narrowly, and no implied or inherent findings made by the court?
Let me go right to the heart of your question, then come back and speak to the constitutionality.
Are you going to refer me to the earlier decision?
Well, I am going to say this.
I don't think it was addressed there.
The city proceeded in this particular instance precisely as the city had proceeded 30 years ago, in which the Supreme Court did not find issue with it, and I understand it wasn't raised. But let's take a look at it. Your state constitution does impose a higher standard than our federal constitution, as is the state's right. It is a protected right in this state, and I think that it's at a premium. And how is that reflected in what your legislature has done? Your legislature has imposed thresholds and burdens that must be met that other states have chosen not to. And I speak to the issue of having a check on the executive power. When Justice Sheehy wrote in 1987 of the frightening power of condemnation, what he had in mind, and I think this is clear from the context, it is a very significant power. And what he was concerned with was an unchecked executive, whether it be a governor or a mayor or members of city council, that they cannot unilaterally undertake this frightening power to take private property. And he's absolutely right. There's a check and balance, an independent branch of the government, the state government, the judiciary. The legislative branch said the judiciary will be the check because there must be a bench trial where the burden of proof must be met by a preponderance that the use, public use, is necessary, or in this instance, more necessary. And without that, it would be unchecked. It would be a frightening power. But that's what's reflected in your state law. With respect to the question you asked about the legislative grant, statutes 4404 and 4403 of Title 70-30. The first section, 03, speaks to the ability for a city with a franchise that's been issued or a contract that has been entered into with the operator of the water system to try to purchase that water system and to pass an ordinance to give notice to that operator. Section 4404 indicates that if that is unsuccessful, if the purchase transaction pursuant to the preceding statute 03 is unsuccessful, then the city may proceed to acquire by condemnation. Defendants would have you read into that pursuant to be a restriction in the second section, 04. In other words, that the legislature meant to strip every city and town in the state from the ability to exercise eminent domain unless they have a franchise or a contract with no public policy that's served by that. If you take the short answer is, I don't read the pursuant to mean anything other than the following. If you undertake an opportunity to purchase in 03, section 4403, that's unsuccessful, you're then able to condemn. It doesn't say pursuant to.
So your position is that the evidence supports, and I guess I want you to explain that there was an effort to enter into a contract with Mountain Water.
To my knowledge, there's no franchise or contract. So there was an attempt to purchase, for sure. That was satisfied under Section 111. But I would ask you to also take a look at the succeeding provision of Title 7, 30-4405, which says that every city in the state has the opportunity to acquire a water system that serves its residents by purchase or by condemnation. If you're looking for a legislative grant that you think is missing in Section 4404, take a look at Section 4405. There is absolutely no restriction, and you won't find the words pursuant to Section 4403 in that section. And I believe that that answers the question fully. With respect to going back to the main theme, which is the evidence that was put on, let me mention one more, and that would be the issue of rate making. How are rates going to be set? Did the court just have some academic, theoretical preference for a governmental exercise of rate making as opposed to the Public Service Commission or some other regulatory body? My answer is, let's see what the evidence was. The evidence at trial was put on by the city with respect to what rate making would look like under a governmental scenario. Mr. Runquist, Mr. Wilson, Alec Hansen, and others testified how it works, how it's worked for years since your legislature empowered cities to do just that. The evidence is there. It's in the transcript. It's in the findings at 92 through 114.
Mr. Schneider, without evidence or without knowledge of what the debt service would be, can the court determine whether the public savings and what the rates and charges will actually be under city ownership?
To the dollar and cent, no. We won't know. I can't tell you today, and you can't determine it with all due respect, because we just don't know the final numbers. But what we do know is that the bonding capacity exists for the number that was awarded by the commissioners in November. And with respect to the point that was made earlier, I believe by Justice Cotter, well, is the district court to look at the appraisal evidence and come up with a range or come up with a figure, and then the valuation commissioners come up with another one? A risk of inconsistent judgments is inherent in any scenario like that. The scenario that they propose that you adopt would run the absolute risk of inconsistent judgments. And what Judge Townsend did, I believe, was highly appropriate. She said, I'm going to look at the evidence as to what a various purchase price would mean for rates in the future. And ultimately, she entered a finding specific to that issue. What did she say?
But excuse me, counsel, we're evaluating public interest by asking the question whether it benefits the ratepayer. So how do you do that if you come in at a fixed valuation? It can be different, and you're looking at what the ratepayer is going to have to pay.
Absolutely. And among the broad range of circumstances or considerations, this is one. Like every other one, it's not dispositive, but the precise answer to your question is, there are demonstrated savings enforced by the evidence with respect to the operation of this particular water system in this particular community, which will obtain at any price. And that was the subject of evidence. And even Mr. Perdue, defendant's expert, took the court through three or four various scenarios. Well, at this figure, this is what would happen. At this other figure, something else would happen. And that's appropriate information for the district court in a public necessity trial. But what defendants would have had the judge do is put on all the appraisal evidence and come up with a figure to conclude, well, the city can't afford it anyways because it's going to be so high, or the city won't want to close the deal because it's going to be so high. And I believe the court made that distinction properly and appropriately and consistent with the sequential nature of the statute, which says you will have a public necessity hearing first. You will then have a valuation hearing later with a different finder of fact by statute. And the two can't be conflated without running the risk of inconsistent judgments.
Counsel, I know you're about to run out of time here, and I want you to respond to Mr. Zadik's representations of harm to the employees of Mountain Water.
Yes, Justice Sweet. The answer to that is in the employees, I believe it's their, let me just quickly direct you to that evidence. That evidence exists. You were told in one sentence. Take a look at findings 180 through 198, which goes from page 56 to 61, entitled Impact on Employees. There you will see what the evidence really was. There you will see what the conclusions were by the trier of fact in that case. In conclusion, I would say simply this. This trial was a model of marshaling the evidence. The evidence led Judge Townsend to the conclusion she reached, not the other way around. Today is the last step in a very important process. We look forward to your decision.
Mr. Luck, before you begin, would you agree that with the statement Mr. Schneider made that the city has the bonding authority?
No,
Or the bonding capacity, rather?
I think the foundation for those statements is entirely missing. The process was, there's an operation named Springstead who took data and tried to decide what kind of dollars might be available based on a lot of assumptions, a lot of untested assumptions. And the evidence is that many of those assumptions did not carry water. But all they did was say, we're going to come up with this number. And then we sent it over to Barclays, who's a different...
But they did put in substantial evidence as to what their capacity could be. I mean, it's a substantial bonding capacity.
Yes, Your Honor, and I'm not trying to avoid the question. I want to get to that. What I'm saying is they put in evidence of bonding capacity secondhand by people taking out of context what other people said and didn't bring the people in that could actually prove it. And my point is that the assumptions and the information fed to Springstead to come up with simply an assumed dollar amount that then goes over to Barclays, and all they say is, oh, if we have this much money, we can issue a bond in this amount. The two don't tie together either with the evidence or what really is coming through. If they really wanted to prove what the bonding capacity was and what they could afford, the people from Barclays would have come in and said, we've assessed all of this stuff and we believe that, rather than getting city witnesses to speak out of context and testify what somebody else might have calculated without getting to the assumptions. So the answer is, we don't know what the accurate bonding capacity is, and if we look at these numbers, I believe it's a big consideration.
So do we find that the district court's findings in that regard are clearly erroneous?
If you are in the substantial evidence determination, I would say the district court misapprehended the evidence, and when you stand back and look objectively, it's clear error, and that's all part of that standard. I think it's important after the presentation from the city to indicate how low a bar the city suggests for exercise of the frightening power of condemnation. Let's not forget even the lead-in to Section 7030-111, which indicates the public interest requires. We need to be talking about the public interest. There's not one word in this record that indicates the quality of the water or the quality of the service provided by Mountain Water as any bit of a problem. Let's look at it graphically. The DEQ, we're talking about all these other systems. The DEQ tested customer satisfaction and indicated that Mountain Water was 4.5 on a 5. Here's 3 of the other biggest cities in the state who have had water systems since the turn of the century, and they're dramatically below that. The poll was mentioned. I'd like to talk about it just because I think it's indicative of the case. The evidence indicated that the poll was designed in the notes of the people working with the city to attempt to influence the court. I don't believe it did. But again, we have litigation strategies, not management plans. The poll was taken on the heels of the finding of an amended incendiary complaint. That, of course, got big news. There's no mention at all in the poll of condemnation. It's all purchased. But let me give you a couple of the questions that the people were asked to consider. For instance, because it does not have to pay profits to corporate investors, the City of Missoula is best equipped to provide our residents and businesses a safe, stable, and predictable source of clean water at the lowest cost. They go on to tell people, the profit that comes from Mountain Water Company in Missoula are helping to pay obscene salaries. What we pay in water rates in Missoula is actually subsidizing the operations of the international private equity firm that owns our water system. Our rates are paying for over 30 corporate offices around the world, mostly in Europe and Asia. It's better to keep the money in our local economy than to pay for corporate profits and bureaucracy, foreign executives, and sky-high bonuses, which is exactly what we are doing. Then it says, thinking about everything we've discussed, what do you think about the ownership? The models are all based on assumptions without appropriate foundation. The record is replete with that. We mentioned taxes. The city pays, or Mountain Water pays $4 million in taxes. Those will disappear. That's not a savings. That's a problem. In the last year, in the record, $1.2 million in taxes paid by Mountain Water went to our schools. Those costs are not going to go away. Those aren't savings. They're going to be distributed. The schools are still going to pay it, but the cities and the taxes aren't going to be paid. The same is true of administrative expenses. I would ask the court to take a look at Mr. Kappas' testimony at 2997 to 2966, because he went person by person and explained the people who were giving rise to the administrative costs and expenses, their expertise and their assistant. Justice Sheehy and Justice Holter recognized that this experience and this expertise at the Home Office creates a value that is unmatched locally. Certainly by taking all of our employees and mixing them up in the city bureaucracy and putting people in charge of the water system that don't know anything about a water system. They know a little about wastewater, but of course you want to be careful there, that they are simply unable to take it and work with it. But those assumptions work all the way through.
Well, Mr. Luck, as I read through this, my understanding is that the city was going to hire all of the employees at Mountain Water now to run the water system. So you're sort of making the same kind of leap that you're somewhat accusing the district court of by asserting that they're just going to be spread out amongst all the other employees and there'll be people running the water system that don't know how to run it.
Absolutely not, Your Honor. The 39 employees of the Mountain Water System are trained 3 deep to do 3 jobs, and that's why they get these efficiency ratings that are so high. The city, in its plan, has a structure that is going to disperse them around the entire system. The head engineer, who's in charge in the management team, who is closely in charge and on top of all the day-to-day activities, is going to go to the bottom of the rung in a department that is not even a water department. That's what's going to happen.
Council, I want to ask you about something that you said earlier, which is that Carlisle has invested the maximum amount the Public Service Commission allowed it to invest. In contrast, Mr. Schneider said that Carlisle has invested no new money, and I'm confused about that fact.
I'm confused too, Your Honor, because the fact of the matter is, let's look at one example. In 2010, there was a 5-year plan worked out through the Public Service Commission on main repair. The Public Service Commission indicated it was cost-effective and good for the ratepayers to put in $4.5 million. Mountain Water put in $7.1 during that period of time. The money that was generated in this system, every single dollar stayed in the system. $4 million in 2013, $4 million in 2014. We're having a little play with words here. The money didn't go to Carlisle and Carlisle give it back, but what's the difference? The money was spent, everything was rolled back in the system. It was not taken by Carlisle. One of the things the record indicates, we talked about the mayor indicating that it wasn't necessary, that Mountain Water is a good steward, that the Clark Fork Coalition agreed with that. And we go through all of the evidence, and it indicates that most of the city witnesses on preference indicated that Mountain Water was doing a good job. There's not one word in this record that the water or the services are deficient in any way. The obvious question is, why? Why did the city even start to attempt to exercise its frightening power to take this private asset? Why did they do that? And more so, why did the district court ignore all these facts in relation to admissions and quality of the service? We have the DEQ, the DNRC, the PSC, the city, the Clark Fork Coalition, all saying Mountain Water's doing a great job. 30 years has passed. The city of Missoula still wants but does not need the Mountain Water system. And the insight and perspective of Justice Sheehy is equally applicable today when he said, whether considered from the viewpoint of necessary or more necessary, the city's case does not hold water. Please don't require a fourth trial.
Now, that was part of a dissent, right?
Your Honor, it is
Right.
true.
I mean, we're citing Justice Sheehy, that's a dissent.
One, wisdom is ageless.
There you go.
Second, wisdom is ageless. Second, he was speaking to those areas of the decision that were affirmed. All of them set out on page 2. Look at those and think about this record, and you'll think it's deja vu all over again. Thank you, Your Honor.
Thank you to all counsel, and thank you all for being here today. The court will now take this matter under advisement, and we will issue an opinion in due course.